Most people assume that filing a car accident claim means that you'll be walking into the courtroom. But what happens for 95% of cases is that the clients actually never see the inside of a courtroom. My name is Max the Axe, the gold standard in personal injury, and I've handled thousands of personal injury claims in my career. We're going to talk about which cases actually go to trial and which cases likely resolve with a settlement and a much better outcome for the client. This way, you don't have to worry about stressing out over the worst case scenarios or having to go in front of a jury, so that you can focus on what actually matters to make your case successful. Here is the simplest way to understand the process in Texas. Number one, a claim is what starts with the insurance company. A lawsuit is what happens if you're unable to negotiate things peacefully with the insurance company. And finally, a trial is what happens after the lawsuit is filed and after all the documents are exchanged and the insurance company still won't budge. Most people skip straight to the last part, and they're worried that if they bring a car accident claim, that means that they're going to have to go to trial in front of a jury. But in almost all cases, the outcome is decided much earlier than that. So let me take you through the timeline in order. Stage 1, the claim and the first offer. After the crash, you notify the other driver's insurance company about what happened. You start getting medical care, your property damage is well documented, and you start collecting evidence. And specifically, we're talking about the medical bills, the medical records, the lost time from work, and any photos that you have. We send this package over to the insurance company along with a very powerful demand letter that explains your injuries and what was taken from your life in the way of health. The insurance company receives the package, they look through everything, they make their evaluation, and eventually they make an offer. Now, in most cases, that first offer that they make is usually a lowball. That doesn't mean that your case is weak, that's just how the insurance company works. The next stage is the negotiation stage. And during the negotiations, if you're not able to come to a reasonable agreement, then the word lawsuit is thrown around. But the word lawsuit doesn't mean that you'll ever see the inside of a courtroom. It means something completely different. Stage 2, filing a lawsuit doesn't mean a trial. A lawsuit is simply a pressure move on the insurance company. It forces deadlines and it forces evidence, and it forces the insurance company to take your case seriously, because once you file a lawsuit, you get a trial date. That doesn't mean that your case will go to trial, but it does apply that kind of pressure to the insurance company. Because for the insurance company, trials are expensive and they're very unpredictable depending on the jury. So what usually happens after you file suit is this: the case gets stronger and the offers usually go up. That's why most personal injury cases happen at this part in the middle, after the lawsuit is filed, but before you ever go in front of a jury. Now, there are still some cases that do go to trial, and here's where that happens. When a Texas car accident actually goes to trial. A case is more likely to go to trial when one of two things are true. One, there's a serious fight about who's at fault. Texas follows a rule called the modified comparative fault rule, which means the insurance company is going to try their hardest to put as many percentage points of blame onto you. They're going to look for any excuse to deny your claim or to slash down the value. And number 2, sometimes trials happen when the damages are extremely high and the insurance company doesn't want to pay for them. Big medical bills, long-term care, lost wages, or permanent injury, those are the cases that the insurance companies like to fight. And sometimes insurance companies like to fight by saying that the injuries were pre-existing or that the treatment was unnecessary. And when there's a huge gap between what's reasonable and what they're offering, that's when trial becomes a real possibility. But before the trial ever happens, there's a long phase that most people don't consider, and it's in that phase that most cases settle. What happens before trial? Discovery and mediation. After the lawsuit is filed, the case enters the discovery phase. That's where both sides exchange information, exchange written documents, ask questions and receive answers, and then they do depositions. Depositions are where the lawyers from one side gets to ask the other side as many questions as they want verbally and receive answers on the spot in a recorded interview, so to speak. Now, this discovery phase can take months. But here's the important part about this, that settlement talks keep happening during discovery. And in many cases in Texas, the courts will require something that's called a mediation. Mediation is a structured meeting with a third party that helps both sides try to come to a settlement. And a lot of cases settle at the mediation stage because once you're in front of the mediator, the insurance company can't lie and say that the case is worth nothing. Fortunately, you have the mediator that's working on both sides. They're talking to the insurance company to try to get their numbers as high as possible, and they're talking to you, the injured party, to try to get your demand as low as possible. And hopefully, the mediator can find a number that works well for both sides to come to an agreement. But let's talk about what trial actually looks like if you do end up going there. What going to trial really means for you. Trial isn't instant. It's not like what you see on TV. It's structured, it's slower, and it involves a lot more waiting around. If your case does go to trial, you may need to testify about the crash, your medical treatment, your injuries, and about what was taken from your life in the way of health. The other side will probably challenge your credibility as a witness. They'll challenge your medical care and say that it was unreasonable, and they'll probably bring their own expert witnesses to say that your medical care was unreasonable or they charged too much money for it. However, if you have a good lawyer, he or she will prepare you properly so you know exactly what to expect when you walk into the courtroom. We don't want you walking into trial completely blind. I want you to know what questions are going to be asked and how do you keep yourself calm and clear in front of the jury. Now, here's the trade-off that you need to understand. Costs and risks of a Texas trial. Trials usually cost more than settlements. They take a lot more time and work, and there are usually additional expenses like experts, depositions, and court costs. But the biggest factor is uncertainty. Even the best cases carry a risk with the jury. Sometimes jurors surprise you in a good way on difficult cases, and sometimes they don't. That's why insurance companies settle so many cases, because they fear the risk as well. So if you're thinking, I really don't want to go to trial, that's fine. You probably won't have to. And here are the steps that you can take to make trial less likely and settlement more likely. How to improve your chances of settling without trial. First, get medical care promptly and always follow through with your doctor's appointments. The gaps in treatment, the time between doctor's visits, are usually the insurance company's number one excuse to avoid paying. Second, document everything. Photos, records, receipts, or a simple journal of what you can't do anymore that you were able to do before. Third, don't try to discount your own injuries and negotiate much lower than you should. If you try to negotiate a case for a very low amount before you ever get a lawyer, the insurance companies will keep track of that number knowing that you'll be willing to accept it. Even if later on your injuries become a lot more serious than you originally thought, it's really hard for the insurance company to reevaluate the case a lot higher after you've given them a very low demand. That's why it's always better to have your attorney negotiate the case first. And of course, the more organized and evidence-based your case is, the harder it is for them to lowball you. Now, let's land the plane. What you should expect. So will your Texas car accident case go to trial? Probably not. Most cases do settle, often during discovery, after filing suit, but before a trial ever happens. And if your case does go to trial, relax, it is a process, and you'll be very well prepared if you have the right attorney. The goal is always the same, to put you in the best possible financial position without unnecessary stress. So let's do a quick recap. Number 1, filing a claim doesn't mean you're going to court. 2, even if you file a lawsuit, that doesn't mean that you're going to end up going to a trial. 3, most cases in Texas settle during discovery or at mediation. Number 4, the trials that actually do happen are when fault is heavily disputed or the damages are extremely high. 5, immediate medical care and good documentation of the evidence makes a settlement much more likely. Now that you really know what happens in a Texas car accident case, here's what you need to know next. Hiring the wrong lawyer can really hurt your payout, even worse than just a lowball offer. So watch my next video, when hiring a lawyer kills your payout in a personal injury case and what you need to know. I'll see you over there.